Tim Hinkle.
Here.
Danny Loggins.
Here.
Michelle Manis.
Here.
Jason Ragland.
Here.
Cindy Siler.
Here.
Andy Tree.
Here.
Wayne Mitchell.
Here.
Quorum.
Jason, you'll say that. Correct, Father, we thank you tonight, Lord, and just thank you for allowing us to be able to gather here together as a community, Lord, and go about the business of the welfare of the county. We ask, Lord, as we go into this meeting, that you just lead and guide on every part of it. Lord, help us to make decisions that would be the best for the community that we live in. We just thank you, Lord, for just allowing us to live in such a beautiful place. We ask all these things in Jesus' name.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Approve the minutes.
Motion approved.
I'll second.
All in favor? Aye. Yes. Jeff, you say you got something for start?
Myself and Laura Gross were called to Little Rock to Performance Review Committee. We didn't exactly know what their agenda was, but there was a whole bunch of senators in there, and the questioning was all about paper ballots. Wayne was there, and so he could also shed some light on how he saw it went. But my feeling was, I personally didn't say too much, but I think my colleagues did. And so we came off not looking great. Our audit was, we lost 2 ballots somehow, and that came out in the audit. And so we didn't come off looking as great as I think we should have, but anyway, just so you know, we did get grilled by one of the committees in Little Rock about the paper ballot issue.
I'd like to add to that. I think Ms. Gross, Commissioner Gross, one of the points that she made repeatedly to the chairs, there were 3 chairs there, and there were detractors. They had the state commissioners were there from the Arkansas Secretary of State. So she was under the gun. When you're sitting in front of an audit committee, you have an unfriendly crowd like that. She had no idea what they were going to ask her at all. She had no idea. She was compelled to appear. And when it came down to it, it really was an issue, as far as I could tell, of Ms. Gross's opinion, and she spoke to the commissioners, state commissioners, as well as the chair, that Searcy County, the election commissioners had no concept or idea how to carry out a hand-marked paper ballot election. There was no procedure that was made available for them, and she alleges, the commissioners allege, that they have repeatedly asked the state of Arkansas for help. And she alleges, the commissioners allege, that there was no help at all offered. And so it is true. I was squirming over there in the seat also, because how can you misplace several ballots? But some of the issues that they were bringing up was, like, for example, someone coming in and signing into the roll, but there not being an attending vote for that person. There was three missing votes that way, so to speak, except that maybe somebody came and checked in and then left and did not actually vote. We don't know that. And the other issue that was a big one was the way they tallied and carried over sheets. The tallies maybe didn't completely match with the machine count, but the machine count matched the ballots, except for those 2 ballots that Jeff's talking about. And so I will personally tell you that I don't think, I think that the state commissioners could have done a better job of equipping the commissioners with information so that she could have showed up at that committee meeting, that audit, with some explanation. But you know how it is, any one of us that goes to a committee meeting without information, you're gonna be flat-footed. So, the commissioners, I'm not representing them at all. I'm just saying that my perspective was that, when you do something for the first time ever, you're going to learn through that process. And she has invited the state to come back and audit the county after this general election. So, I'll tell you, Ms. Gross threw this out, I'm out of hand speaking this, but I don't think that the commissioners would have a problem with a hand-marked ballot system where the machine counts and that is certified with an audit of the paper ballots, which would definitely make the process a lot simpler and easier. And I'm not speaking for the commissioners, but this is a process, it's what I observed, and it was embarrassing. But I think that the commissioners, as Mr. Cotton understands how hard that job is, that they definitely should be thanked. They don't get paid for what they do, and they work their butts off, and they worked hundreds of hours to understand the process, and there was no malfeasancy at all. It might have been a procedural thing, but they worked their butts off to make sure that we had a fair and honest election in this county. That's what I perceive. And I think that the clerk would also attest to that. It's just that we do need to improve, and they plan on doing that during the general election.
Are we supposed to have a choice where they can use machines for paper?
Yes, ADA requires that you have those machines, and so any individual could go and vote on the machine or the paper.
So, are they required to tell them when to come in, they can do either? Don't know about that.
I did not hear that that was a stipulation.
I know we did
Okay.
not do that.
Okay, I just wondered. I've had people ask me, so.
But what I'm looking forward to, and I feel like the Quorum Court's on the hook here a little bit, because we heard the commissioners, we received the report, we voted, and what we all agreed to was that if it is not burdensome to the county as far as expense, then if the county wants to do this by majority, and there was a lot of people that involved themselves here in this Quorum Court, then our job, I think, is to listen to what the people want, and unless it is expensive. And so the one requirement is that they come back to this Quorum Court with a report. And now that ES&S has released the figures for what the county's expenses are going to be, and we know what manpower is, the commissioners will show back up with a report. And then we'll make our decisions going forward. We still own those machines, and you know, if it doesn't work out to be a good process for us, we can reverse.
Good deal. Okay, we got old business, resolution 2024-6.
I'll read only on this one.
I would recommend it. Just explain what it is.
Yeah, I make a motion that we suspend the rules and, go title read only on resolution 2024.
That's second.
All in favor?
You have to explain what it is.
A resolution affirming the ownership of Calf Creek Lodge, number 426, F and AM, to Lot 1, Block 2 of the original town of Marshall, Arkansas, and authorizing the county judge of Searcy County to execute a quitclaim deed to Calf Creek Lodge, number 426, F and AM. So basically what this is, the lodge came to us last month, and there's some kind of hiccup with their title on their building over here. And they're wanting us to quit claim any possible ownership of anything beyond this wall, beyond the cross wall. Basically wanting to make this cross wall between here and there the legal description of the property.
And I noticed they did add that into the legal description. As I read it, correct, along the south wall of the Jeff Jennings building.
So basically what it would do would just be to clarify that that wall is the boundary legally.
Motion and second.
I make a motion to approve. approve resolution 2024-6.
Second. All in favor? Any opposed? Okay. Got appropriation ordinance 2024-35.
Is this an ordinance? Never mind, it's general ordinance.
35.
2430.
It says 36 on the front page, but we've got a 35 here.
Yeah, it's supposed to be 35.
Okay.
35.
Appropriation ordinance 2024-35, being enacted by the Quorum Court of the County of Searcy, State of Arkansas, an ordinance to be entitled to amend the 2024 annual operating budget to appropriate funds to allow the county judge to administer said appropriation, whereas the county has received from the Department of the Interior a payment under Payments in Lieu of Taxes Act in the amount of $166,870. Therefore, the following appropriation is approved. From Fund 6400 Buffalo River to Fund 1000 County General in the amount of $166,870. Whereas this ordinance herein enacted is an appropriation ordinance and therefore is effective immediately.
Judge, I have a question. Is this a one-off or is this like is it biannual? Is this a one-time, so it's biannual?
Oh, it's every year.
I mean, like, will there be another tranche of
This year?
money coming in this year from this source?
I don't think so. I think it's one every year it is.
So this can't be dependent on hitting, say, in October, November?
I don't think so.
I make a motion to approve appropriation ordinance 2024-35.
I'll second.
All in favor? Any opposed? Okay, we got new business, ordinance 2024-34.
I make a motion that we, since this is a general ordinance, although it does say it's an emergency clause, is this an emergency ordinance or is it a general ordinance?
It says it's an emergency.
Emergency clause. It's an emergency clause.
So we don't have to suspend the 3 consecutive days. I make a, you wanna read this thing?
Well, I don't care to because of what it is. I mean, it is lengthy, but
It's a big deal.
ordinance 2024-34, being enacted by the Quorum Court of Searcy County, Arkansas, an ordinance to be entitled an emergency ordinance for the protection of the traveling public, condition and maintenance of the county maintained public roads in Searcy County and within its unincorporated limits to declare an emergency and for other purposes. Whereas Searcy County, Arkansas has over 960 miles of county maintained public roads. Whereas the Quorum Court finds that the public interest is served by protecting the county maintained public roads and ability of the county road crews to be able to maintain the county maintained public roads of this county. Whereas it is necessary to adopt this ordinance to assure the county road crews are able to maintain the right-of-way, public road easements, roadway, subgrade, culverts, and signage for those county maintained public roads. Whereas the Quorum Court finds that public safety and public interest is served by protecting the traveling public from the placement, creation, or existence of physical and functional encroachments or obstructions to county maintained public roads. Therefore, be it ordained by the Quorum Court of Searcy County, Arkansas, Article 1, the purpose and applicability. The road easements or right-of-way for county maintained public roads in Searcy County, Arkansas shall be inviolate for the county road purpose and free from the existence of functional and physical encroachments or obstructions, except where written permission is granted and issued by the county judge. Article 2, county maintained public roads. For purposes of this ordinance, county maintained public roads shall mean any road identified as a county road assigned a county road number and maintained by the county, or any road in which the county has directed construction, material, blading or grading, maintenance, mowing, or repairs of the road, roadway, or right-of-way, road easements, or bridges. Article 3, shall be unlawful and a violation of this ordinance for any person or persons or organization to engage in the following activities on county-maintained public roads: to create a physical or functional encroachment within the road easement or right-of-way for a county-maintained public road. B, throw, dump, or place any item or items onto a county-maintained public road, including but not limited to the county roadway or road beds, shoulder, ditch, subgrade, right-of-way, easement, slope of the ditch, or any county-maintained public road in the unincorporated areas of the county. C, dig or place or situate any utilities, poles, lines, fences, cables, wires, or any item whatsoever within the easement or right-of-way of the county-maintained public road without first obtaining the written consent of the county judge and comply with the utility accommodations permit requirements of the county. D, any item or items, fences, gates, whether closed, locked, or unlocked, obstacles, physical or functional encroachments within the road easement or right-of-way of a county-maintained public road shall be by or at the expense of the owner of the property. E, burn anything within the county road easement or right-of-way of a county-maintained public road without permission of the county judge. F, create a physical or functional encroachment by the diversion or placement of water onto the roadway, subgrade, right-of-way, or road easement to create an impairment to public safety or the ability of the county to maintain the subject county road. Or G, park a motor vehicle, trailer, camper, mobile home, equipment, or item within the roadway, road easement, or right-of-way of the county-maintained public road, except during an emergency due to malfunction, in which case the property shall immediately be removed from the roadway or driving surface to assure the safety of the traveling public. In no event shall the property remain parked on the shoulder of the roadway for over 48 hours. Article 4, penalties and remedies. A violation of this ordinance shall result in a fine of $1,000 for a specified offense or violation, or double that sum for repetition of the offense or violation. And B, if the act or violation is in the nature continuous in respect of time, the fine for allowing the continuance of the prohibited unlawful act or omission in violation of the ordinance shall be $500 a day for each day that the violation is unlawfully continued. C, any item or items, fences, gates, whether closed, locked, or unlocked, obstacles, physical or functional encroachments within the roadway, road easement, or right-of-way shall be moved by the expense of the owner of the property. D, the county may exercise self-help and remove any items, fences, gates, closed, locked, and unlocked, obstacles, physical or functional encroachments within the roadway, road easement, or right-of-way of the county-maintained public road, and shall be reimbursed for the cost of removal. E, the citizen or landowner with standing and or county judge may pursue a declaratory and or injunction relief from the court of competent jurisdiction for removal of an obstruction to county-maintained public roads. Or ACA 5-71-214 provides that a person commits the criminal offense of obstructing a highway or public passage if, having no legal privilege to do so, and acting alone or with another person, he or she renders any highway or other public passage impassable to pedestrian or vehicular traffic. ACA 5-71-214C further prescribes The criminal penalty for obstructing a highway or other public passages is a Class A misdemeanor. The county judge, any citizen or landowner may notify the sheriff of the violation. Criminal penalties under ACA 571214 are not in lieu of the civil penalties prescribed by this ordinance, but are in addition thereto. Article 5, severability. If any provision of this ordinance is found to be invalid by the decision of any court or competent jurisdiction, such invalidity shall not affect the remaining sections, phrases, and provisions of this ordinance which remain valid and enforceable. Article 6, the emergency clause. The Quorum Court finds that the immediate implementation of this ordinance is necessary for the preservation of the public's peace, health, safety, and welfare and property. An emergency is hereby declared to exist, and this ordinance is to be effective immediately after its adoption.
Judge, I hate to ask a question about this, but when it comes to burning in the, like in the bar ditches, I know a lot of people burn leaves out and all that. This is just something.
It's, a lot of places got plastic culverts
Okay.
and they will burn out.
I understand, okay.
That's why Everett County, he sent one to Everett County to do this.
Yeah, that makes sense, okay.
Be good if you clean the ditches out.
Trash being so abominable.
Trash bins. Is that an issue?
They need to be far enough out of the road that they ain't causing problems.
Okay. So, like in line with, or behind like where a mailbox would be located?
They need to be behind the mailbox, please. Motion? Got any more questions?
Make a motion to accept ordinance 2024-34? Yeah.
I'll second it.
All in favor?
Aye.
Any opposed? Okay, I've done it. Resolution 2024-8 that Chad's been working on today that we sent out late. Commercial lease.
Do a title read on this one.
This is the one you sent today, the lease, the
Okay.
commercial lease. And if you have any questions about it, Chad probably could answer them.
Well,
Or after you read it, or.
we're kind of working on that legal issue though, right? Or the legal description issue.
Yeah, that's on the other one.
Yeah, well, we get that legal description. So, we've been working, this is for the economic development project with the factory. And, got the lease is there ready to go. There's a mortgage that is a condition of the grant that EDA is requesting, the federal grant is requesting as a condition of the grant. And in looking at that, in looking at legal descriptions and surveys that we've had at the shirt factory, I think we decided we need a little more research into the legal description.
We'll probably have to get it surveyed.
Yeah.
See, it's showing the whole community
You got
center.
baseball fields, community centers, you don't want that tied up with this grant. And so I think it'd be better to get as restrictive a survey as you can get.
Just to build it probably.
Yeah. So if you wanna approve the lease is there, but the legal description is not ready on the lease because it's gonna be further curtailed by that, survey. If you wanna approve that, that's fine.
Is this lease, in the meeting that we had, I don't think this lease was like the first thing that had to happen. Can we table this till?
The lease, like the other deal we're working on, we're gonna have to have pretty quick, but the lease, I think we can do it actually after we get the build it done.
Cause they had to do engineering, if I recall, engineering drawings. Where are they at on that?
We met Monday and he looked it over and went back, and so I don't know how long that's gonna take. Could be a month, could be 3 months, I don't know. You know how the engineer and architects are, so. That's our holdup right now.
And so the engineering needed to be done in order to bid it, right, to let bid?
Yeah, they gotta know what to do, right, so.
I make a motion, we table this until the, August meeting, so that, Mr. Chad could have a chance to amend this with a legal description, which I think is good.
I'll second that.
All in favor? Any opposed? Hey, just got anything?
Bill?
Anybody out in the audience got anything?
I do. As a former election commissioner.
Yep.
Been quite a while since I served, and some of the laws might have changed. According to this court, Searcy County is to do paper ballots. State law requires that an ADA machine be available for anyone that needs it.
That was noted in my reply, that every polling center or every center where people vote will have ADA compliant machine.
If required.
Well, they are required.
No, if they require a machine.
Yes, I just say yes. I mean, you're a commissioner. But they are, every polling center does have.
Yes, sir, I understand that, but not everyone should be allowed to use the machine. We
Oh.
voted on paper ballots.
Oh, well, I
We
think.
require people to use paper ballots, but if they're handicapped and cannot, then that machine is there for them to use.
That's a great point.
Hearing
but
or
I don't
blind or
think-
something.
I don't think the commissioners are requiring paper ballots, it's an option, but that was a point brought up at that meeting, so that's a great point.
Yes, sir.
I don't think they're requiring the voter to use paper ballots.
Well, when you start sending out information that you're not required to use the paper ballots, what I'm trying to avoid, then you're gonna end up with half the county using machines and half of them using paper ballots, so.
I
I'm
think
just
what,
trying to stop that before the rumor gets out that you can do either one.
I think what Clerk Cotton was saying was that when the voter goes into to vote, they would be advised that either or is available to them. Is that what you were saying, sir?
No, that's not what I said. What I said was, what happened this election was that the electronic pencils, that voting machine was there for people that needed it to comply with ADA. The poll workers did not advise any voter that they had the ability to use either or. They did not do that.
So is that it's just an option, it doesn't follow, I mean, you don't have to be like if you were handicapped, it's anybody, so you're saying anybody that walks in there and votes has the option to use paper or the machines?
I'm not saying that, no. That's not what I said.
That's not what he said.
I think what Tommy is saying, I see your point. If the public is advised they have an option, then that would, I guess, dilute away.
Absolutely. Why did you pass paper ballots if there's an option?
Right. What I did say was that this committee that met, they indicated that we should have given them the choice. In
And
other
that's where
words,
I was going, like,
yeah.
why
There-
if it's not a require, I mean, why are we even giving them a choice if we don't wanna, if you don't wanna go there just to give everybody
I'm
a
not,
choice? So
I'm
that
not
makes
sure
sense
either
that
way. I don't know if
that
I
that
was thinking that was part of the law that was written in there, and that was my question. When we discussed that, why go to paper ballots if we're gonna have to have machines anyway? But I was thinking that was.
May I speak?
Yes.
The requirement for the, Jeff, please correct me if I say anything wrong. I'm a former election commissioner. I'm just trying to keep down the.
Understand.
The ADA, the state law requires that an ADA machine be there, not for everybody to use, for people that need the ADA or handicapped available machine. It's not there for the general public. But if you have a handicap, if you're blind or have trouble seeing, you can also get poll workers to help you fill out a paper ballot. They could be 2 poll workers to come and read you the ballot and help you if you're blind. You can do it that way. You don't have to have the machine even then. But if you require a machine for your handicap, that's what the state law requires.
I think, in answer to your question, I think the reasoning behind the hand-counted paper ballots, it was considered to be not only possibly a cost savings in the future, but most importantly, a measure of security, and it was felt by some that, the hand-marked, hand-counted paper ballot did provide that, so that's why the committee recommended it, and that was the reason why the Quorum Court voted the way that it did. It was not really just a cost savings issue, although that was brought forward as a secondary benefit. But, it doesn't really relate to the Quorum Court, I guess, but the commissioners should determine that point that you made, because I don't know.
Well, if we may just continue the discussion, Mr. Cotton said that they suggested that you offer the option of machines or ballots, that's state commission. It is not a state law that you do that. So if they can run our elections just by suggestions, that's not a good place to be.
And as Andy pointed out, though, he felt that the resolution was that the county be a hand count paper ballot, except where ADA applies. And that's not apparently what would be in line with what the commissioners at the state level were saying.
What the commissioners at the state level were suggesting.
Right, but if the resolution doesn't say that, you see what I'm saying?
If you go, I don't have the resolution in front of me, but I believe if you read it directly out, you would say that Searcy County shall use paper ballots. And then you cannot go against the state law, so you have to have a machine. So you have the left hand and the right hand. Forgive me. I just don't want that rumor to get out there that they can use either way.
I assume that they could.
Yes, sir.
That's-
See,
that's
assume.
There you go.
Never assume.
Forgive me. I'm through.
Anybody got anything else?
I will bring it up to
Ms. Gross, yes.
Ms. Gross.
Yes, she's the commissioner now.
I'll bring it up.
Forgive me if I made a mistake.
Last month we discussed the fire dues, and Mark Whitmire sent us, directed us to Arkansas Code 1420-108. It's 2020 Arkansas Code, Title 14, Local Government, Subtitle 2, County Government, Chapter 20, Quorum or Levying Courts, 1420-108, dues for volunteer fire departments. Now, we looked at ways that we could do that. According to this law here, and according to what Mark Whitmire says, the only two options that we have are vote or a signature. I'll go ahead and read what this says, since I love to read so much. It says, when the Quorum Court receives a request for the levy of volunteer fire department dues, and the request has been signed by the fire chief and chair and the secretary of the board of directors, if any, the volunteer fire department, and filed with the county clerk, the Quorum Court by ordinance shall call for an election on the issue of levying the volunteer fire department dues on each residence and each business having an occupiable structure. 1, the issue may be placed on a ballot with a special election by order of the Quorum Court in accordance with 7/11/201. The special election shall be held by August 1st. If any attested petition is filed by the county clerk and signed by a majority of registered voters in the volunteer fire department district voting in the immediately preceding general election, then the Quorum Court by ordinance shall dispense with a special election on the issue of the levy of volunteer fire department dues. If the volunteer fire department dues is approved by the majority of the voting on the issue, or the county clerk determines that the number of the signatures of required voters is sufficient, and the Quorum Court dispenses with the special election, the volunteer fire department dues shall be listed annually on property tax statements and collected by the county collector at the same time and in the same manner as real property taxes. Talitha mentioned the magic wand.
Mhm.
Mark Whitmire said these are the only two ways to do it.
Can I speak?
No, yeah, I really.
So, Wednesday through Friday is the collector, conference in Fayetteville, and I'm going to be attending that. They're going to have some sessions on this topic, because this topic is a hot topic across the state. The magic wand, I did not come up with that on my own.
Right,
That was
right.
given to me by Saline County, Garland County, Faulkner County, Crittenden, and, there's another one. Several counties had used that.
Yeah.
And I've asked them repeatedly, did you have to have a special election? And that I've repeatedly been given the answer, no, the Quorum Court did it. So, I'm not trying to argue against him, I'm just
Right.
the messenger and information provided. So, I will know more about it Wednesday through Friday. But I can tell you, Searcy County is not the only one that is looking at this. But I can tell you, there's a lot of counties across the state that collect this, just like normal. And everybody processes them differently. Some remove it off the books at a certain date, some hold it on the books and prevent their residents from getting tags, and I mean, they're hardcore serious about it. Those counties have paid fire departments, so I can understand their seriousness and their commitment. It's a different conversation if you're having to budget annually for that. You've got to have some promises and guarantees and commitments. I don't know, I've been talking to people since the last meeting, and I'm continuing to hear the magic wand.
Can you explain to us what the magic wand is? I want one.
Right.
What is it?
It is a code, and I didn't bring it with me, I apologize, I left my file at work. But it's a code, and the third option on that allows the Quorum Court by unanimous vote to put the fire dues on the statements.
There are
Which-
counties right now doing that.
Do what now?
Counties are doing that without following this procedure.
They did not have elections, they used, their Quorum Court made the decision to put it on there.
Mr. Chad?
Well, now, the ordinance that Mark sent us, you have the election option or the petition option. And so the petition would avoid the election, but you do have to get signatures from a majority of your voters. So I think, I think Choctaw and Van Buren County, Choctaw did this years ago, and I think basically you get a petition form and you get all of your people to, figure out all the voters in your district, and you pass it around, and you get a majority of them to sign the petition. Then they can come to the Quorum Court to have the Quorum Court pass an ordinance.
For that particular
And
district.
yeah.
How would you get a majority of the voters in the district or in the county when the voter rolls are not really accurately reflecting how many votes? And I don't mean that.
I really don't know the answer.
I'm not being derogatory, I'm just asking that honest question.
Well,
It is an honest
goes
question.
by the vote in the prior election before.
I think your question is how do you determine whether the voter is in that district?
No, I mean, how do you know how many voters, how many signatures you need? You're saying it's based on how many voted in the first.
Percentage of,
Yeah,
Mark
say
Whitmire told me that
Okay.
Jeff Collins shouldn't over.
Say if
Oh,
there's
yeah.
there's 1,000 people,
that voted.
501 people have to.
So if 1,000 people voted in the previous election,
So it's 51.
then you have to get
You're gonna have to have 500.
The voter roll.
50 plus one,
You can filter the voter rolls by
Well, it's
fire
gotta be
district.
registered voters.
Sure.
They said they
Okay.
didn't have to
Okay.
vote prior to year before.
Right.
It's gotta be registered. What Mark Whitmire told me.
I mean, we're
I'm not
only
against
talking
looking
1,600
into
votes.
What you're saying
Total over
too.
the whole
I'm
county.
just saying, this is what
I understand.
ACA, this is what they've said.
Well, her magic
Well-
wand sounds like her petition.
The good thing about it is the Association of Counties will be there this week. They're going to be involved. And yes, I have a notebook with questions.
If you can get us some answers on why, we would appreciate it.
Based on who is conducting the session, I anticipate a lot of magic wand discussion, because it's the counties that provided that information that's conducting the session on it.
We just wanna make sure if we do it, we do it the proper way.
And it's a big deal if you can't get a tag because you haven't paid your dues. That's how serious some of these counties are.
Is that on the paid you said fire department?
Excuse me?
The ones that are mandatory for the paid fire departments, is that what you said?
The majority of them are the ones that are real
Yes.
committed, but not all. Some of them are considered voluntary, but they still hold it.
Recognize Mayor Gator.
My question is, the city of Leslie, we've already got a tax that covers our fire. Will we be affected?
I don't think Leslie won't, Marshall won't.
Okay, because we've already got a tax to cover our fire, so.
Yeah, they compulsory take my fire dues, so I don't have an option.
I have also would like to offer, I have not heard from any county that has a set across the board. They have their individual departments make the determination of what the amount is. I know we've had a lot of discussion, well, a bit, about it there being a set. I know the two offices, being the collector and the assessor's office, have had a lot of discussion. And it is kind of the overwhelming idea that it needs to be set across the board for everybody there. But I've not found a county that's doing it that way yet.
It just look like it'd be easier on the.
Absolutely, thank you very much.
Well, Searcy County seems to have no problem with breaking the trend, so we can certainly do that.
That, I mean, you
Well, I
know,
think once we
you know,
figure,
that's,
once we figure out what we need to do, how we need to do it, we need to get fire association, all fire departments to get together and decide if they want it to be voluntary or if they want it to be mandatory. If they wanna set it, see what they want, because if we do wind up having to go with the signatures or the election, if they opt for the election, the fire departments have to pay for it. And the signature drive will be totally on the fire departments and the fire association, if that's the route we have to go. It'll totally be up to them, so they're gonna have to be boots on the ground, working together and making decisions on what they want, so we can make a decision on it. All I've got.
Anybody got anything else?
I'd like to just find out why we can't find other options of revenue, even for the fire departments, before just, yes, I understand we already have the dues in place, and right now it is voluntary, and they mail them out once a year, and it's not on our taxes, which, I'm sorry, I am a taxpayer before I'm a JP, and I don't want my taxes raised. I pay our fire dues, and that's just the way it is, but I also understand they ain't gonna get there before everything I own is toast anyway, if I was to have a fire, God forbid. But there's gotta be other ways to find avenues before raising our own people's taxes. Because in this county, we are tax poor. I love Leslie, they've got 9.5% tax, is that correct, 9.5? So, 6.5 goes to the state, then you've got the county, then you've got your city. We get nothing from our tourists, we get nothing from any other type of revenue in this county other than raising our taxes. And there's got to be another way.
I don't want to dissent, but my opinion is that as the county grows, I think it would be advisable to provide adequate fire protection for the residents of the county. And I've heard that only 20% of the people who would be benefited by fire protection are paying their dues. And so here's you can look at it this way. You pay your dues to the sheriff's department, and then they'll come out and they'll take care of you in a crisis. But if you don't pay your dues, they don't come to your house. Well, everyone gets law enforcement protection. Everyone gets the protections that the county provides. And for, I don't know, I'm just speaking freely with you. I think
Yes,
that
absolutely.
fire protection is a big deal for the
It
residents
is a big
also.
deal, but
I understand that costs continue to go up. But
exactly.
but like for me, mine's voluntary, and I pay it or I don't, but if I pay it, I'm like you, I write a check every year. So really, there's no additional cost, there's no additional tax I'm paying every time I purchase something. It's just gonna be on my tax statement, whatever that set amount is. So, I mean, it's not gonna cost me any more unless I'm paying 35 now, so let's just say it goes to 50, it'll cost me $15 more just because I've always paid the 35, but it's not a tax that I would pay on every time I purchase something. So I'm already paying it, it's not gonna cost me anymore. Now it's gonna cost my neighbor that doesn't ever pay fire dues. Yeah, it's gonna cost them something,
Well, when
but
you-
I don't really look at it as a tax.
Well, see, there's some that do because they're based on their incomes. I mean, we have more fixed income people in this county, honestly, per capita than we do working people. I mean, that may or
And
may
that's
not
to me, yeah, and that's a service that's optional. I mean, if you have a fire and you don't have fire dues, then you're gonna be responsible for the bill.
But they never charge. And-
But if they do,
But think about
let's
this.
say you didn't pay for 20 years, you've had a fire, they come out, they bill you for $250, and you've got 20 years without that extra cost. I'm not saying we shouldn't pay it. I'm just saying there should be other options before we just add it to their taxes.
But it could be that if everyone pays their part, it could cascade out and reduce everyone's cost.
It could, I
You know,
understand
instead
that
of it
too.
being, the fire dues are set at a certain level because it's already built into the system that 80% aren't gonna pay. And so if everybody paid $20, then maybe, everybody gets, the fire departments are funded. Okay, so now I'm feeling a little annoyed.
I'm sorry.
Because, I mean, these guys, they work their butts off and they slave
I understand
to
that.
try to keep the oil change in their vehicles and keep tires on there. They're underfunded, and, the people of this county expect, if my place catches on fire, I'm hoping somebody comes to help me. We always paid our fire dues. And so, I just think it would be logical to let the fire departments make that choice, to let the people determine whether they want that. But I think in the end, it would actually save money because the cost would be cascaded equally across everybody. But as the county grows, you're gonna find that more and more people are going to depend upon the services that these men provide.
I understand that too.
But I understand what you're saying. I mean, you start adding taxes, everything keeps going up and up.
Right, and it's not just, and it's not a stab against our
But it's
volunteer
actually
fire
not a
departments.
tax,
I appreciate that, but at the end of the day, if we're going to do something, if we have to go that route, we should also put it in the hands of the voters. I don't think it's something that we as a quorum have, which, as Jason has stated, which is how he reads it, the way Mark Whitmore has explained it too, that we have to do it that certain way, petition with
Right.
signatures, or we have a special election. But if we get a magic wand, and we take that right away from the people,
I don't think that that's the case, though. It sounds like you gotta get a petition, but it has to be 50% plus one vote, right?
per district.
And so, is it per district or countywide? I don't know, but the people are speaking at that point.
Countywide.
Yeah, so the people are speaking,
But what about the cities that aren't included in that?
well, it wouldn't apply to us, because we don't pay dues.
Or I understand that, but that wouldn't be, the count numbers would be lower too, wouldn't it? I mean, if you have 8,000 population, but say between 3 cities that may already collect that tax, so now you're down to 5,000 people.
I think it's households that pay, I think it's a household that would pay, not
Is it
the
for property or
individuals.
for structure?
Yeah.
I think it's,
Structure.
Structure, yeah.
So if you have 20 acres, you have a house and 2 shops, and then you have 20 acres over there with a barn and an old house. I mean, are you paying for all of that?
One figure pays for all.
Yeah, one building
I think Jason did it say
Oh,
livable
livable
structure.
structure.
Livable or usable? So like, didn't you say usable? Yeah.
I'm amazed that
That's
these guys
the barns.
do what they do,
Yeah.
honestly. I mean, you guys go out there for free and you bust your butts and you put your life on the line, and, I mean, I'm not countering what you're saying. I'm just saying that I think that the volunteer fire department should be supported. And-
I think so too.
And so, I hope that your initiative passes personally, but
If you've never been on the fire department, you don't know how many hours they put in.
You guys are heroes.
32 years. It's a lot of
I
time.
appreciate
they put
your
in.
job.
And they go to a lot of wrecks and.
Yeah, ranch,
stuff
medical
like that.
calls, and, yeah.
Two
Some
things,
stuff
if
I
I
couldn't
could
do.
say 2 more things. So there's some people out there that are going to see it on the tax statement and it's just going to automatically become a tax. It's not gonna be a bill that they formerly paid. They're gonna see it on their tax statement, it's gonna be, they raised my taxes, because they don't understand taxes.
But
So,
it's a
you've got
fee.
that struggle, okay? But then, you've also got the other thing that no one's really talked about. We're wanting to support our fire departments and increase and give them what they need. Right now, the volunteer, or the fire dues are voluntary, you can pay it or not pay it. So if you choose not to pay it, and you have one of the largest fires, that starts one of the largest fires Searcy County's ever had to deal with, does that department fine the original? Do they bill them for going out there? Because I can tell you pretty much across the board, the answer to that is no. So your fire departments are probably gonna have to take some deep self-searching and look at that as well. Am I promoting everybody to be fined for a grass fire? No, I'm not.
It's
But I am
hard-
saying
it's hard
that's
to-
the flip side of
But
the
it's,
coin.
it's hard to find your cousin and your uncle.
It is.
Your brothers and your sisters, so I know that's why, that's the way it is.
But then you've got the other neighbor down the road that's like,
I know.
write the check, you know? But that is the flip side of the coin.
But it's not a tax, it would be a fee.
It is a fee.
A lot of time to think about.
And actually, it's labeled as a fire due. That is how the counties are truly labeling it, a due.
And that is one thing that fire departments would need to decide if they wanted to be mandatory or voluntary.
I would,
I mean, there is that option
it wasn't,
of mandatory or voluntary.
anybody got anything else? Dan?
Somebody else does.
We adjourn.
All in favor?
you.